All right, and we are now recording.
Okay. All right. I'll let you line up those words there. Thank you, Kristen. And thanks, folks. I also wanted to let folks to know to feel free to use the chat if you have questions, and Kristen will be monitoring the chat throughout the presentation. And we do have time at the end to answer questions. So if you need us to slow down, or you have something that you really feel like is urgent, you want to share or ask, please do so. If not, know that we're going to add some time at the end to answer your questions. So I want to really start out by thanking Kristen for your tech support. As I said, when we were getting ready for this, I don't know what we'd do without that. I have not caught up with all this stuff. I've learned how to be on a Zoom and how to talk into a computer, but that's about as far as I've gotten. So thank you, Kristen Vermenta, for your support. I also want to thank Caitlin Bradley, who's an attorney at the Action Alliance for the PES, People for the Empowerment of Project for the Empowerment of Survivors, for really pulling this together and making this series that we dreamed up a while back happen. So thank you so much, Caitlin, for all your support. I want to thank our partners, the Virginia Poverty Law Center and Susheela Varky, who's going to be co-presenter on a number of these trainings. So thank you, Susheela. And I also want to acknowledge our intern, Shelby and Mary, who put together our PowerPoint for us. So thank you all, and thank you for making this production work.
Hey, Ruth, this is Kristen. We're seeing in the chat that some folks are having a little trouble with hearing you. Is there any way that you can adjust where your mic is or speak up so that it comes through a little bit more clearly?
Well, okay, I'll try to talk a little more closely. Let me see if I can up my output a little.
That seems like that's making a difference. Thank you.
Okay, good.
There we go.
There we go. That sounds great.
All right, is that better?
Yes.
Okay.
Appreciate it. Thanks.
Sure thing. Thank you, Kristen. So just to give you a quick introduction about what this series of trainings around protective orders is going to be and why it's going to be in 4 different sessions. There's a lot of information that we wanted to share and communicate to folks. And we decided to do that in 4 shorter sessions instead of doing like really long Zoom events. So today's is going to be the sort of history and the background of protective orders in Virginia. What was the original intent, and what's been the progression of them over the past, gosh, 25, 30 years. Session 2, which is going to be on September 17th, at the same time, is going to be the nuts and bolts of protective orders. So this is a real detailed overview for folks who are really learning about protective orders and what they're intended to do and how to access them in your communities. Session 3 on September 24th is going to be around enforcement and application. And that's going to be a panel of legal aid attorneys. And you will be able to submit questions prior to that Zoom event, as well as ask questions, I believe, when you're on there of the panel. And then the final session will be October 1st, and that's going to be focused on firearms and protective orders. So it's going to really look at some of the new firearms provisions related to protective orders and talk about how to have those begin to be effectively implemented in your community. So that's sort of the big picture, the overview of the whole series. And I'm going to turn it over to Susheela and let you talk a little bit more about what we're going to do today, and introduce yourself.
Thank you, Ruth. Hi, everybody. I'm Susheela Varky, and I'm with Virginia Poverty Law Center, which is the statewide legal aid in Virginia. So what that really means is that unlike the typical local legal aid attorneys who tend to be in court every day with huge caseloads, we at Virginia Poverty Law Center don't tend to go to court. We're more focused on lobbying, advocacy, systems change, and trainings like this. So part of having said that, I will say that I've spoken to a lot of you as well as advocates and other service providers around Virginia who can't get a legal aid attorney to represent your client. You end up calling me to brainstorm. So you have my contact information, and feel free to contact me about anything. And just moving on to the next slide, slide 2. This is just an overview of what protective orders are, what they're supposed to be. I'm assuming that you all are familiar with what protective orders are. They are civil protective orders. As Ruth said, we're splitting up this training into 4 different trainings. So Caitlin is going to go into more of the nuts and bolts of protective orders in next week's session. But the point of a protective order is that, as it says on this slide, it's a way for us as a society to say that this kind of behavior that abusers are engaging in is bad and needs to be punished or stopped. And it's a way for survivors to guide the process and have some agency, some power over this civil protective order process. So the point is that when you have a protective order that is enforced, you are able to de-escalate violence and prevent further crimes from happening. But the one point I want to highlight on this slide is that protective orders, even if you meet your burden in court to be able to get one, they are not necessarily the best thing for every situation. And Ruth and I will talk more about that today, as well as throughout the course of this 4-part series. And one thing I wanted to mention before we move on is that I have shared, we all learn differently, right? So Kristen was kind enough to share this PowerPoint with you all. There's also a document, it's more of a timeline of many of the things we're going to go over today in this PowerPoint, the timeline and the history of protective orders, but also some other related laws and things that were happening in Virginia, so that you can have that too as a trusty little cheat sheet to kind of keep aware and know your history of protective orders. Yeah, and Kristen just put that in the chat. So Ruth, I'm gonna let you take over for the next couple of slides with slide 3.
And just to reiterate, if as we move forward, could y'all please both try to speak up, just to be mindful of the folks who may be having a little bit of trouble. Thank you. I know that our internet access very much affects how clearly our sound and video are coming through, so I apologize for that. And that is one of the reasons that we're trying to record.
Are you all able to hear me okay?
I can hear you just fine. For the other folks who are here, if y'all could put something in chat. I'm seeing somebody saying only okay, but not great. And some people are saying not very well. So it's kind of hit or miss.
I just put my volume all the way up. Does that help?
I'm not really hearing a difference on my end, Susheela. Is there any way you can get closer to where the output is?
Uh, I'm pretty much, it's right on top of my desktop
Okay,
monitor, and I'm right at it.
gotcha. Sorry, folks, this looks like it's going to be the clearest that we can get. Please know with the recording, we are going to be putting that in a space where there will be some subtitles. So hopefully that will make it a little bit easier. And again, you do have access to the slides. But please message me if you're continuing to have some trouble, and I will try to reiterate the need for speaking up in case we start to drop down a little bit. Thanks, y'all. Appreciate it.
Okay. So I'm going to be really close to my computer so that folks are able to hear. So I apologize for the face up in the screen like this. So, but I want to make sure folks can hear. So I'm going to do a quick summary of how protective orders came to be and why we have them. Which I think folks are probably aware of now, but there was some real need for a civil option that worked for survivors of domestic abuse and what we called back then spousal abuse. So back in the early 70s, when we were really looking at options to provide safety and protection for victims of violence, we really looked at ways to create options that were not necessarily criminal, because most folks did not necessarily want their partners or their husbands or wives to be going to jail, but wanted the focus on an intervention to be having the violence stop. So when we were establishing shelters for victims of violence to go to, we looked at ways to establish some sort of legal interventions. And what we came up with were the concept of protective orders. And back in the 70s and 80s, they were actually called spouse abuse orders. So we knew that we needed something that was expedient, that if you were being abused in your marriage, in your relationship, that something that could be utilized to create a safe option, and you could stay in your home or you could leave your home, that was other than a divorce, which took at least a year back then, and most often longer than that. So it was an option to create safety that could work more quickly and did not necessarily involve having to wait for a divorce. We also looked at an option that was affordable, one that people could do pro se or without having to have an attorney, and an option that allowed for both safety and individual agency and control. So a civil option allowed for folks to be able to petition to the court and request relief. And it did not require a punitive remedy such as criminal charges might. So it really was created to allow for that safe option very early on. Okay, change next slide, please. Just a quick, to put this in context, in 1977, Pennsylvania was the first state to pass protective order legislation in the United States. Many states quickly adopted protective order legislation for spousal abusers, as it was called back then. And in 1984, the Virginia General Assembly passed the first spousal abuse protective order legislation. When that legislation was passed, it was a penalty for violating a no contact or no abuse provision of a protective order was a class 3 misdemeanor and was really the same as trespassing. Next slide. So actually it took a couple of years to get it to be a class 1 misdemeanor, to be that, have a violation. And then from about 1985 up until the early 1990s, there were very few changes to protective orders in Virginia legislation. In 1991, then Attorney General Mary Sue Terry created a domestic violence task force. And that was when we really had some significant changes in the legislation and really put some teeth into protective orders. So we made protective orders available to family and household members. So we expanded it beyond just a spouse being able to access a protective order. Legislators recognized the need for children and for other relatives living in the same household to be able to access protective orders or to be part of the protected parties. And that's when they created the definition of family and household member. And we really looked at a broader range of intimate partner violence and family violence, and made protective orders available to a wider group of folks. Also, prior to 1991, protective orders were, you only had a preliminary order and a protective order that was good for up to 1 year. And you had to go to court services, petition for that order, wait to get on the docket, which sometimes took quite a while, with the exception of the preliminary order, which you could petition for if you had an emergency need. So the legislators really began to look at sort of the differences and the need for more protection that was more quickly available. And so the birth of emergency protective orders came about. And there was quite a bit of controversy around allowing these emergency protective orders because it allowed you to essentially move someone out of their house or force someone to leave their home without hearing both sides of the issue. And the idea was that it would not be any more than 24 hours. And certainly what we've learned over the years is that there are courts that don't meet, where you have a circuit judge who covers a number of localities. There are courts that don't meet for up to a week. And then there are holidays and weekends and that sort of thing. So there were many changes to the emergency protective orders because they were never intended to last as long as they do in some jurisdictions. It really was to allow somebody the opportunity to leave their home and get to safety. So emergency protective orders have definitely evolved over the last 30 years. Hopefully we'll talk more about that. And in 1994, with the passage of the Violence Against Women Act, we saw the federal full faith and credit laws implemented, which essentially said that protective orders were good across state lines. And again, we will talk a little bit more about full faith and credit as we go through this series. All right, next slide. So the other sort of big change that happened around protective orders was the recognition of the need for protective order for people who were stalked. And the difference that was really opened up, the big shift, was that a stalking protective order was available to non-family members. One of the differences and where the civil protective order option sort of crossed over into some criminal law was that you had to have a warrant for stalking to request a stalking protective order. So we actually started attaching sort of a higher level of need or proof around obtaining an order. But we did allow folks to obtain a stalking protective order, and that was a pretty significant shift in our movement from spousal abuse to understanding that there were other things happening to people who were not necessarily family or household members.
And I think you can move to the next slide. Thank you, Kristen. So just to segue from that, just to make sure people know the difference. So for family abuse protective orders, and Caitlin's going to go over more of this, you have to have a family or household member relationship, and you would go to juvenile and domestic relations court to get that protective order, to ask for that. And in JNDR court, they have court services units where you go through an intake officer to file the paperwork. If you don't have that family or household member relationship, that was the point of having this other type of, used to be called stalking protective order, that would allow a person, whether they had the family or household member relationship or not, to request a protective order. But as Ruth said, you would have to prove either stalking, that there's a warrant for stalking, or for some other type of criminal sexual assault in order to ask for that stalking protective order. And in 2003, the relief available from that stalking protective order was expanded to include criminal offenses resulting from injury to person or property. So you could get relief for that type of an injury. Next slide. So Ruth mentioned full faith and credit, and let me just talk a little bit about what that is. So it's part of our Constitution, and most of the Constitution is about the federal body of law versus state law. But full faith and credit is about how states treat each other's laws. So for protective orders, the concept is, if I get a protective order against an abuser in Virginia, that protective order, no matter what state or territory I'm in the United States, should be enforceable as it would be here in Virginia. So basically the point is that all protective orders, state protective orders, whether they're issued in one state or another, can be enforced in every state and territory. And the respondent, that's the abuser, would have had a notice and opportunity of the hearing. So that really means they'd be served with documents and have notice of the hearing and have the opportunity to be able to come and defend themselves in court. That's due process. That's the concept of due process. And the same thing, it's not just that Virginia orders are enforceable in other states, but other states' orders are enforceable here. And some of the nuances change regarding, like, let's say, in a Maryland order, someone from Maryland has a protective order where the respondent had the opportunity to be heard and had notice of the hearing and all of that. They want to enforce it in Virginia. Virginia, even if that protective order would not have been issued in Virginia, Virginia judges are going to have to enforce it as if it were, and they're going to use their own enforcement measures, law enforcement, etc., to enforce that out-of-state protective order. So you can register your protective order, out-of-state protective order, as a Virginia protective order. There's a process to do that. But even if you don't do that, if you don't register your out-of-state protective order in Virginia, it is enforceable in Virginia. So I'm going to just stop here for a second and see if you guys can, on the fly, do a little response to my following question. Why would a person not necessarily want to register their out-of-state order in Virginia now that they're here in Virginia? Just post in the chat and I'll see what you guys write. I'll just give it a couple of seconds, like maybe 10 seconds to see what you guys are writing. And if you don't write anything, I'll answer you anyway with some ideas. But there might be very good reasons why a person chooses not to register their order as a Virginia order. What do you think? What do I say? Yes, Chantel Garber, awesome. So if you're registering it as a Virginia order, it's possible that the respondent, especially if it's violated, and the respondent gets served with, notice of a hearing for the violation, that respondent might now know you're in Virginia if it's registered as a Virginia order. And maybe that's not something you want this person to know. So yes, you don't want to be found. Excellent responses. Thank you for that. So if you guys have more questions about full faith and credit, feel free to ask us. And I'm thinking it may come up, especially in the next couple of 2, 3, and 4 series of this webinar series. All right, next slide. Okay, so this slide is talking about 2011. And let me give you a little backdrop on what was happening around this time in Virginia, and it'll kind of situate why these changes started happening. So there was a young woman, a UVA student named Yardley Love, who was, she had broken up with her boyfriend, another UVA student, and was experiencing violence and harassment from him. Because she did not have a family or household member relationship with him, they were both students, they were ex-boyfriend, girlfriend, but they didn't have children together, etc. They didn't live together within the past 12 months. For all of these reasons, they didn't fit the definition of family or household member. So Ms. Love was not able to, at that time, get a family abuse protective order against him. She would have had to prove that, there was either stalking or criminal sexual assault and get a warrant for that in order to ask for a stalking protective order. So this boyfriend ended up murdering Ms. Love, and this was in Delegate Rob Bell's jurisdiction, and he has been a real, supporter of victims' rights over the years. So this is the backdrop of how we came up with these amendments to the protective order, the stalking protective order, which now officially is just called protective order, but it's basically the type of protective order that you would get if you didn't have a family or a household member relationship. So some people call it the non-family protective order or general district court protective order. So we basically came up with what the bad behavior is that we want to stop with a protective order, and that is an act of violence, force, or threat that results in bodily injury or the threat of bodily injuries, criminal sexual assault, or death. So if a victim or survivor is experiencing that type of act of violence, force, or threat, if she or he has the family or household member relationship, she would go to JNDR court to ask for that protective order. And if they didn't, they would go to General District Court to ask for that protective order. So basically making protective orders available to people who were dating other types of intimate partners, or even people who had no dating relationship, who don't fall into that definition of family or household member. And a really important part of this, you can move to the next slide, is that you no longer needed to get that warrant for stalking or criminal sexual assault. It's just, if you have the relationship, family or household member, you go to JNDR to ask for your protective order. If you don't, you go to General District Court for your protective order. So as it says on this slide, the relief available, I went over what the act of violence, force, or threat is. You could get no further acts of violence, force, or threat, no contact, and then all of these other conditions depending on the circumstances that might be helpful to that particular survivor and their family or household members. So this type of protective order, like the family or household member protective order at that time, you could have, once you get that protective order, the respondent cannot purchase or transport a firearm while subject to that protective order. So back then in 2011, this did not include a prohibition on possession of firearms. Okay, you can move to the next slide, which I think Ruth is going to start talking about, and I'll mute myself.
Okay, thank you, Sush. Yeah, so another big change around protective orders that happened in 2014, and I guess I just want to let folks know that just about every General Assembly session, there are attempts to make changes to protective order legislation based on whether it was a really horrific event that happened in a particular legislator's jurisdiction, or whether it was a number of different events, but really folks trying to look at what are the gaps in protective orders and how do we make them stronger tools that folks can utilize. So there was a real push again across the country around connecting animal abuse and domestic violence. And for folks who work in the domestic violence field, you probably are very well aware that where there's domestic violence, there's very often an abuser who harms the animals as well. If you're in a rural community, you know that happens, that folks won't leave, or that things happen to animals beyond companion animals that are more farm animals, goats, chickens, cows, horses, that sort of thing. But what we were able to get passed in the Virginia General Assembly was a section that allowed the petitioner to request possession of a companion animal. And that companion animal has to fall under the definition in the Virginia Code, which is essentially around primarily dogs and cats, or it could be an animal that is not considered livestock, but lives in the home, is under that companion animal definition. So you want to make sure that you are able to access that definition and understand the distinctions around requesting them. And I guess the other point I want to make with that is that livestock is considered property, and that petitioners can request access to their personal property when they petition for protective order, so that there are ways around getting possession of animals beyond companion animals. But that was a pretty significant change in 2014. Okay, next slide. And again, we just wanted to take this opportunity to reiterate what the restrictions around firearms were at this time. So it has been a fairly consistent restriction around both family abuse protective orders and the stalking or non-family abuse protective orders, where the respondent was not allowed to purchase or transport a firearm during the duration of a protective order. And that has been standard practice, or at least standard law. Essentially, when a protective order is entered into VSIN, which is the Virginia Criminal Information Network, that goes to the state police, who then can monitor and post who's not allowed to purchase a firearm. Now, of course, that's from a registered firearm dealer, so there are always challenges there. And then the transport piece, and that's been interpreted in many different ways. Some judges have interpreted that if the respondent walks across the room with a firearm, that could be considered transport. The typical way that's been interpreted is carrying a gun, you know, if you're going hunting, or if you have a weapon with you in your car or something like that. So there has been in the past restrictions around purchase and transport of firearms. So the big change that happened in 2016 in Virginia, and let me just back up a little bit, and I don't want to confuse folks too much, and this can be particularly confusing, which is why we're doing a number of sessions around this. The federal standard around federal protective orders, or where somebody may cross state lines, there has always been a restriction around possessing a firearm. But in Virginia, that restriction had not been there. And primarily, any attempts to restrict firearm possession had been essentially impossible to get through the Virginia General Assembly, which was controlled by Republicans and very pro-Second Amendment Republicans. And so any attempts to make a restriction on possessing a firearm had been virtually impossible. This change actually happened when Governor Terry McAuliffe made essentially a deal with the Republicans to place this restriction on possession of firearms when there was a family abuse protective order in place, and made it a Class 6 felony to possess a firearm for the duration of the order. And that only applied to final orders and final family abuse protective orders. And one of the things that I think we've been really struggling with as we travel around the state is helping communities even know that this law exists and then put in place ways to enforce that. It passed in 2016, and when we've done surveys and reached out to communities, have learned that even law enforcement isn't aware of this particular law. So it's really important that advocates understand this and know that these restrictions are are there. And as we move forward, we're going to find out that it gets even better. Okay, next slide, please. So 2018, one of the things that, one of the significant changes, and again, we bring this up and we want to let folks know that this is a requirement in the statute, is that the clerk of court in both J&D court and general district court is required to provide the petitioner with a list of local resources of domestic violence services when they petition for, not when they petition, take that back, when an order is issued. So every time an order is issued, the petitioner should be handed a list, a sheet with that has the local domestic violence services on that sheet. And that is something that if you're working for a domestic violence agency, that you want to make sure that the court is providing to petitioners of protective orders. And that was a pretty significant piece of information, because victims really need to be working with advocates around safety planning when protective orders are issued. And I'm sure folks have heard the statement, it's just a piece of paper, it doesn't do any good. And it may be that folks have actually made that statement or said that a protective order is just a piece of paper and doesn't do any good. There are many things that need to be in place in order to back that protective order up. And this is one of the things that we hope will help connect victims with advocates. Okay, next slide, please.
Before we move forward, can we pause really quick just so Susheela can reiterate something that was put in the chat about the final family abuse POs?
Yes, ma'am.
Thank you so much, Kristen. I just put in the chat that when Ruth is talking about in 2016, this deal between Governor McAuliffe and the Republicans about the final family abuse protective order, she's talking about the 16.1279.11. It's in the chat. You can just put that citation in your Google and find the actual language. This is the, I call it either final or up to 2-year protective order or full protective order. This is the kind that would be obtained after either the respondent had been given notice of the hearing. This is usually after the preliminary protective order has been, served on the respondent, and let the hearing, let's say the respondent hasn't been served the hearing for the full protective order. Most judges are gonna postpone and reschedule and give that respondent another opportunity to come and defend themselves. So this is after that has happened or after the full hearing, when petitioner and respondent have both given their testimony and the judge has said, I believe the petitioner and I'm going to issue this 2-year protective order. So we're only talking about those protective orders. And we're only saying that basically no possession of firearms is only available as of 2016 for the final or full family abuse protective order. And then I will just continue. You can move on to the next slide, Kristen. So as Ruth said, every session, and I haven't been doing this as long as Ruth has, but I've been doing this since 2008 session. And every session there is some type of proposal or several proposals about protective orders. This year, frankly, with the Democrats in control, a lot of us brought proactive bills about protective orders to the General Assembly. So these are some of the ones that passed. So as Ruth was just saying, in 2016, a respondent in a 2-year family abuse protective order could no longer possess firearms. All of those years, 2017 on, we've been trying to get that no possession mirrored on the non-family abuse protective order side. Finally, that has happened, that it's now a Class 6 felony to possess a firearm if you are a respondent in either the family abuse 2-year protective order or the non-family abuse 2-year protective order. And there are some proactive requirements of the respondent. Respondent is supposed to surrender their firearms. This slide says to an appropriate entity. We can talk a little bit more about what that is, but it's on the respondent to get rid of that firearm, their firearms, within 24 hours of being served with the protective order. The appropriate entity can be somebody who is not prohibited from possessing a firearm. It can be law enforcement. And like I said, we'll talk more about this, but some of the issues are that there's no requirement of any law enforcement or any other type of agency to go collect these firearms that are supposed to be surrendered or store them. It's a voluntary thing that some law enforcement agencies are doing. The respondent also has to certify to the court that issued that protective order that they've surrendered that firearm. It's a certification form that they have to fill out and submit to the clerk of the court that issued their protective order. And then if they don't do that within 48 hours, they can be held in contempt of court, which can lead to, you know, consequences, right? Including potentially jail time. So I wanted to just stop there and bring those up to you because part of this 4-part training is for you all as advocates and service providers to understand what the law is so that you can help survivors and victims understand how best to protect themselves, right? So often it's going to be the petitioner, the survivor, who knows that the respondent hasn't surrendered their firearms or has only surrendered one of many. So that's where the enforcement part has to become a community-wide endeavor. Also, on this slide, there's the new red flag laws, substantial risk orders. These are orders that law enforcement or the Commonwealth's attorneys can ask for if there is someone they know of in the community who has firearms and is considered a danger to themselves or other people. The substantial risk protective order, it's actually called substantial risk order. And there's an emergency substantial risk order, which lasts for up to 14 days. Substantial risk order can last for up to 180 days. And Commonwealth's Attorney's Office can ask to renew it indefinitely. So that's a way to get firearms away from a dangerous person. So to me, this is the first time since July 1st that this is a new law. I'd like to hear from you all if your Commonwealth's attorneys and law enforcement are using this type of order, how you're able to interact with folks and work to help them identify people who should have these orders taken, these firearms taken away from them. And then another type of order I want to mention is when certain violent felons, so it's only certain types of violent felonies, once that person has been convicted of that crime, that violent felony, the circuit court judge can issue a protective order that is way longer than 2 years if the judge deems that necessary. It can be up to the lifetime of a defendant. So if the defendant is getting a life sentence, that protective order can be issued for the life of the defendant. So I wanted to make sure people knew about this because we certainly know of our survivors who have dealt with extremely dangerous people who have tried to kill them, committed extremely violent felonies against them. And instead of having to come back to court every 2 years to ask for a new 2-year protective order, this type of protective order is going to be available to certain types of victims at the criminal conviction hearing or sentencing hearing. All right, so you can move on to the next slide. And I think we're both going to talk about this, so I'll just keep talking. But basically, as I said in the beginning, protective orders are really a tool that it's really best used when understanding the dynamics of the particular person's situation with their abuser. Even if in court you would meet your burden of proof to get your protective order, it may not be the best, safest measure for a particular survivor. It may raise the ire of the respondent. It may escalate violence. And if you think about it, especially in certain circumstances, if this is, say, the first time that a survivor is actually going to court to ask for a protective order, she's going to a public situation in court, asking a judge in public to give her some protection from this abuser that can be seen by the abuser as defying his authority. And even though she is right to ask for that and may get it, it may not be the best option for that particular survivor with this abuser. So talking about safety planning, and that's where you all come in. I'll let Ruth add. I know that she wants to say anything. I see her nodding her head. So go.
Yeah, thank you, Sush. Yeah, I mean, we are actually planning a whole training around safety planning and what it means and what's involved. And we thought this was a really good opportunity to talk a little bit about safety planning and why protective orders are not necessarily the best option for everyone. And if you're in a rural jurisdiction, I'll use this as an example. There are folks, and not just in rural jurisdictions, but there are individuals whose firearms are so important to them that even the notion that their firearms would be removed is enough to escalate that violence. And you're not necessarily going to know that, the advocate's not, but these are important questions to talk through with a victim. And when a victim says, you know, yes, a protective order sounds good, I think that would be helpful, and they don't know that once this protective order is issued, that the respondent's going to be required to turn over their firearms. But they understand that if that happens to their partner, that they're going to be so angry or so indignant about that, that it's going to increase their violence, the potential for violence. The victims know that. The victims know this information, but they may not know that by petitioning for protective orders that that's going to happen. So part of that safety planning involves, we need to know what's going to happen if somebody gets a protective order issued, and we need to prepare folks for that. I think another thing to think about, and what we need to know in safety planning, is the level of coercive control that's exhibited in that relationship. Because there are relationships, intimate partner relationships, where the physical violence has never been too bad or where it might have required intervention. But if you dig a little bit deeper and you talk to that individual, the sexual violence might have been going on, or certainly sexual coercion, but the level of control that's there are the indicators that there's going to need to be a lot more safety planning than just filing for a protective order. And I think with these additional restrictions, even though our intentions are really good when we add new relief to protective orders, the often unintended consequences are more restrictions on the respondent, which then can escalate the behavior. I'm reading your chat. You mean that for the PO that the petitioner may ask? Yes, yes. Yes, so the petitioner, I'm going to answer the thing that, the question that Susheela just brought up in the chat in response to my statement. As of July 2020, the petition will now, the protective order petition will now have a box that the petitioner can check requesting firearm relief. And it's important that somebody is explaining to them what that is, so that they understand what it is they're asking for and what that process will be. You know, so again, we really wanted to reiterate the fact that safety planning cannot happen in 5 minutes. It cannot happen in 15 minutes. If you just meet somebody in court to help them access a protective order, safety planning really involves a conversation with that victim and understanding their particular situation. And I imagine we will start to see fewer and fewer protective orders issued with these new firearm restrictions. And that may be okay, because there's not an option for the petitioner to say, oh, I just want a protective order, he can keep his guns. It is now a Class 6 felony if a protective order is issued against someone for them to possess a firearm. So again, significant change that we want folks to be aware of and think about.
And I know we're going to talk more about firearms, especially in the session 4 that Ruth is going to lead. But one thing I wanted to bring up about this is, and I'll use an example. Let's say in your community, with this new requirement or allowed relief that the petitioner can ask for firearms relief in her own protective order, and that may lead her to not want to ask for it. That would be where you all as advocates can work with her and the Commonwealth's attorney and law enforcement to determine if there is a safer way for law enforcement or the Commonwealth's attorney to ask for firearms relief in the substantial risk order, so it's taken off the survivor's plate, not having to put her in a position to defy the abuser. Let law enforcement and Commonwealth's attorneys handle it as a community problem. So that's why I mentioned the substantial risk order, for you all to become familiar with it and to work with your Commonwealth's attorneys and law enforcement when that might be a better option than for the survivor to ask for a protective order for herself.
Yeah, thank you, Susheela. That's, and we will talk more about ways to do that. And those are definitely things, if you have a good, strong community response or a good CCR, coordinated community response in your community, these are really important issues to be talking about for how you might want to deal with some of the more high-risk domestic violence cases. So that sort of takes us to that systems advocacy piece about your role in ensuring the effective issuance and enforcement of protective orders in your community. So once upon a time, most communities in Virginia had a local coordinated community response to domestic violence. And that was very similar to what a SART is in communities, but really focused around the response to domestic violence. There are currently some communities that have good, strong CCRs in place. And then there are some communities that do not. And in order to really have strong, effective protective orders, you really need to have that community response. That doesn't necessarily mean you have to have a team, but it means somebody has to be paying attention to all of those things that need to be in place to have effective enforcement of protective orders. Protective orders are still a really effective tool in many cases. And so we're not by any means trying to get folks to not utilize them. We really are trying to have folks refocus on what the law says, what the purpose of them are, and how to utilize protective orders as a tool in a safe and supportive way for victims. And you play a really key role in doing that. You know, when you look at the fact that a law was passed in 2016 requiring respondents to not possess firearms, and the majority of law enforcement agencies in the Commonwealth did not enforce that, or many said they weren't even aware of that law, then it is incumbent upon us as advocates to know these things and then to make sure that our community knows them as well. And even from a social justice perspective, it's important that the respondent knows that if they try to purchase, transport, or possess a firearm while they're subject to a protective order, it is a Class 6 felony, and that they can be arrested and put in jail. And so it's really incumbent upon all of us to make sure that this information is out there in communities and that folks know about it and are utilizing the tools that are available in order to utilize. And one of the other points I want to make about all of these changes with protective orders is that we often get tons and tons of legislative proposals to make some change in the protective order that some constituent has brought to their legislator because the protective order did not work the way that it was supposed to work. And very often, it's not because we need a change in the law, it's because we are not effectively issuing and doing the pieces that are in place to make sure that we can effectively enforce them. So there's a lot of background in enforcing protective orders, and we really want to make sure folks have access to the information to understand that and be able to educate your community members about that as well. And Sush, I don't know if you want to talk any more about the emergency risk order.
No, not really. Just that what I've said already, just to make sure you're as part of your relationship building to know your Commonwealth attorneys and your law enforcement and ask them how they're using it or proposing using it, or if you think of a way that they can use it for someone for whom it would be better for them to ask for that type of order than for your survivor to go through the protective order process. And just, you know, as Ruth said, coordinated community response teams don't necessarily need to be meeting every week or every month or even every other month. It's more that you have the relationships with each other, with other advocates, with law enforcement, with the different service providers, and you keep feeding that relationship so that you can build that trust that comes from a coordinated community response team, where you can address a problem as a community. An abuser who is a problem not just for the survivor of the violence, but for the community and future partners. So I would just say that. And the relationship building, you know, when I met Ruth, it was when I was working for the courts, right? The Office of the Executive Secretary of the Supreme Court of Virginia. They're the administrative office of the courts in Virginia. And that was a grant with, at the time, I think it was 6 agencies altogether, maybe 5 or 6 agencies. And we literally got to know each other. We all had different roles on the grant. The grant was to basically figure out how to improve the service and enforcement and effectiveness of protective orders in 6 different places in Virginia. So by doing that, traveling together, which I know is not possible now during COVID, but we've developed the relationships that now last even after people have retired, where we can brainstorm and do all of that relationship building that helps us solve problems for our survivors. So it's important work to do, I would say, especially now during COVID, when you are basically just meeting with each other via Zoom. You're not doing that in-person stuff. It's all the more important to maintain those relationships with your other service providers. But yeah, that's all I had to say here. And I think we can move into questions if you have any, unless you have anything else, Ruth.
Yeah. No, thank you, Sush. And yeah, I hope we'll be able to dig deeper into some of the systems work that is required to really have effective issuance and enforcement of protective orders. I remember having, you know, week-long statewide conferences about protective orders like 10, 15 years ago even, and they're even more complex now. And it's important to not assume that the system is all set up and working without problems. It's really important to pay attention to that in your communities and play a role in making it an effective response, because they are and can be very helpful tools to folks. So yeah, we've got a little bit of time for questions, and I don't know, Kristen, if we can see everybody. I know for me, I like to see everybody. What I see on my screen is just me. It's kind of disconcerting. Thank you. And it might sort of help to generate some questions. Also, just to let folks know that this really is this is to get you thinking, to get you thinking more about what your role can be in making protective orders a more effective tool. and to be prepared to dig more deeply, and we will certainly be having more discussion as the weeks go on. So I'll be quiet and see if there are any questions.
And I'm also wondering, Ruth and Susheela, if this would be a good time to introduce that assessment tool.
Oh, yes, absolutely. I'm sorry. Thank you, Kristen. Let me tell people a little bit about that. So are you going to put it in the chat?
Doing that right now.
Okay. So I want to acknowledge that this assessment tool that Kristen is making available needs to be updated, and we have a commitment to doing that. And hopefully by the end of the series, we'll have it updated with the new firearms laws involved. But this assessment tool was developed by that group that Susheela just referred to when we met. This was developed out of a grant when a group of us from the courts, from DCJS, VPLC, and not VPLC at the time, that was when you were at the courts, right?
Yeah, it was you all, the Action Alliance, DCJS, the state police, courts, and the OCME, the Office of the Chief Medical Examiner.
Yes.
And then the grant then added the AG's office, and then the state police fell off, the courts fell off, VPLC came on. So it actually still exists now with Action Alliance, VPLC, the AG's office, Office of the Chief Medical Examiner, Department of Criminal Justice Services, and VVAN, the Virginia Victim Assistance Network.
Yes, thank you. But this tool was developed out of that partnership. And this is a tool that you can use to assess your own community. You can take it to your community team, and you can really use that to look at what's in place in your community and to learn more about what's involved in the issuance and enforcement of a protective order. So feel free to copy that, to use it, and also we will make sure that you get an updated version of that, but it's certainly still relevant to sort of check in your community about how you're set up to effectively issue and enforce protective orders. So yeah, feel free to use it. If you have questions, contact Susheela or myself, and we can walk you through it. We can present it at a community team meeting. We can talk about how you just sort of do a check on your community about how well you're doing protective order enforcement. So,
Ruth, you kind of went out there on that last part.
okay.
Sorry, if you could repeat what you said just quickly.
I don't remember what I said. Please contact us. Yeah, Susheela or myself, if you need somebody to come out and walk you through that with your team, present the assessment tools, or walk the team through how to utilize it. We are available to do that, and more than happy to help you use that as something that helps strengthen your protective order response in your community. So, yeah, and to answer your questions.
Yeah, and part of the tool, it's a lot easier than you'd think. Just reading each line, and you could do it with your own staff and just say, hey, do we even know what that means? Do we know if that still exists? That's part of it. The questions that you have of your own by going through it that sort of trigger things that need to be addressed in your community.
Okay.
Apparently we're awesome. That's all I'm seeing. No questions.
Yeah.
I put in the chat that, of course, if you have questions that come up, we are resources to you. feel free to call us or email anytime, especially if something comes up that you didn't either remember or it seems new to you. Feel free to contact any of us anytime. We'd be happy to, if we don't know the answer, we'll find it for you.
Yes, and please be sure and log into session 2 on September 17th, Thursday afternoons from 2:30 to 2 to 3:30 are Thursday protective order time. So we're gonna get really good at this stuff, and be sure and log into the whole series, because there is so much to discuss and learn about how to do this. So I just want to thank everybody. And again, please follow up if you have questions. And this is an opportunity to think about questions that you might want to ask our panel on the following protective order, on the third one of the series. You can also ask on the second one too. So, yeah. Everybody have a great afternoon. Take care of yourselves. These are not easy times. And we look forward to talking to you next Thursday afternoon.
Thanks,
Thank you
y'all.
so much.
We're stopping the recording now.
Thank you so much, Chris.